Hello, everyone. Welcome to the second edition of the Legal Chat, a YouTube version of the Self-Storage Legal Network's Legal Power Hour. As you can see, I'm Scott Zucker, and next to me virtually is Carlos Caslow. And we are going to have a legal chat on the hot legal topics of the self-storage industry, and want to just invite you to join along. Carlos?
Yeah, welcome everybody. We're glad that we have another opportunity to sort of talk to you about the developments in the exciting realm of law of self-storage. And there's been developments in legislation and litigation. And there's if you're Scott Zucker, a litigator, there's never a dull moment.
Never a dull moment. And for you, keeping up with the legislation, boy, it's been a big year in the self-storage industry on legislative changes. So I know our audience is probably pretty interested in keeping up what is happening that affects their operations. So, yeah, Carlos, where do you want to start?
Well, I think we should start with what I believe to be the most important legislative development in the self-storage industry, perhaps since the initial enactment of the lien statutes back in the 1980s. And
drum roll. Okay.
I know. I really think this is a big game changer. There's I know that the Georgia legislature has enacted what we'll call, I think what we sort of refer to as a self-help remedy for non-rent defaults, and where tenants stay in the space. And today, in most states, or at least last year in most states, you had to essentially go to court to be perfectly safe and that kind of thing, because you were acting as a landlord. It was an eviction, it was an unlawful detainer, depending on the state you were in. And I mentioned that Georgia enacted it, and California legislature did too. And we have 4-day wait now to find out if the governor is going to sign it, let it become law without his signature, or veto it. And we're hoping that the last option doesn't occur. So, but we'll know this weekend exactly what's going on. And I think it's a big deal in California, especially because unlawful detainers are, for self-storage operators, they're expensive. Unopposed unlawful detainer costs $3,000, $5,000. Could be more. They're slow, 6 weeks, maybe it could go into months. So it's not an optimal situation. And you run into problems even being able to do some basic things like service of process, Scott. Is that, and that's a problem.
Yeah, well, again, the tenant's not living at the facility, presumably not living, although that may be a basis for the non-monetary default right there, is that they are using it as a residential location. But yeah, you have, most of these eviction procedures, and some courts are a little more lenient on what I would call the taking over the possession of the space as compared to the personal jurisdiction of trying to recover something from the tenant individually financially, is the fact that most states will require service on the person. And if you can't find the person, you can't complete the eviction. So there's a lot of challenges to these evictions or unlawful detainer actions. And you're right, these states that so far have approved the non-monetary default process, Georgia, Idaho, and Kansas, and having those laws go into effect really do help self-storage operators deal with what I would consider to be, phraseology-wise, a bad tenant, a tenant who otherwise would pay the bill, but is otherwise acting badly, not following the use requirements of the facility, acting aggressively, maybe committing vandalism, certainly storing property that the facility doesn't want to be stored. These are all non-monetary defaults. And now this gives an opportunity for the landlord to act in response to the tenant behavior by having terminated them. And then if they don't vacate post termination, allowing for the removal and disposal of the property. Like you said, a self-help remedy without getting the court involved.
Yeah, and it really just expands something that we've been, self-storage operators have been doing for, well, over 40 years now in some states, since the early 80s. And that remedy is proven to be, I think, in most instances, fair and, not particularly, that controversial anymore. And I think this will probably be in the same category because, the one thing self-storage operators don't really like to do is get rid of tenants that are paying them the monthly rent. I mean, they're doing it because the relationship has gone south. And the tenant's living in the storage space. The tenant is doing something. They might be loitering at the facility and trying to and interacting with other tenants that may not want to interact with them. So I mean, it's not something where, oh yeah, let's just get rid of this guy. I mean, it's something where we're being paid money, and in the ideal situation is let's keep this guy around. But unfortunately, it just doesn't work that way. But again, having self-help in this area is really big. And I think if we get the governor's signature in California, that in and of itself will be a big deal because I think it will be influential in states like New Jersey, Illinois. Well, California did it. It's not that, it probably makes sense. So again, and just realize that the goal here is not that dissimilar to what we did with the lien law back in the 1980s and early 90s. The goal is to actually have this remedy, and it'll be a little different in each state. But essentially, there'll be some kind of notice that goes to the tenant. If the tenant doesn't respond with a certain amount of time, you can dispose of the property, sell the property, not unlike what you do with the lien statute. So again, it'll be familiar, but again, it won't be exactly like the like the lien law. It's going to be a little bit different. So I'm really excited about this. I'm hoping things work out in our state in the next few days, and that we have this remedy for the self-storage operators.
Yeah, I'd like to add a sort of a cautionary tale, though, with respect to this new right that's granted self-storage operators in these particular states that have enacted the law, as well as some states that have what we've seen over the years to be, quote, abandonment provisions in the statutes, which might articulate a basis for an operator to dispose of the property based upon certain actions of the tenant that might be deemed to demonstrate abandonment of the property. The act of disposing of tenants' goods with the self-help remedy, and you know I'm conservative in nature about this sort of thing, is really a last resort remedy. I don't want operators getting too enthusiastic about the fact that they can send, under these statutes for the most part, a letter of termination, and then as quickly as 14 days after sending this letter, disposing of their tenants' goods. I think that you need to build a case of tenant non-monetary default, opportunity to cure that non-monetary default. I mean, look, if it's a criminal activity or something like that, pretty dramatic, that's one thing. But if it's just this sort of ongoing, maybe bad behavior, violation of use, notice, cure, I mean, that's building a case. I just want people to be careful with this right. This is a heavy sword. I think you'd agree.
Oh, no, I agree. I mean, I think storage operators have, generally are pretty good about having used the lien remedy. They don't, they tend to go through the process fairly carefully. And, it's not something that they particularly want to do. And I think this is the same thing. The one difference here is you're probably going to have a customer, who's at your facility who has really been causing you a fair amount of annoyance, because that's why you're going to want to use this remedy in the first place. I want this relationship over with. But you can't allow that to, to really think through that this is a process. And if I do it right, the way that it is laid out by the legislature, I'm going to be okay. I'm not going to be facing, substantial liability. But again, it's a remedy that you want to use with care, and you want to use it when you want it there when you need it. It's not something you use casually. And again, I'm not that concerned about that problem. I think most operators, again, if they're paying the money, you're leaning towards the thing, how can I fix this?
That's absolutely right. So along with these termination non-monetary default changes to the statute, we've seen some other statutory changes with regard to the enforceability of the lease agreement that I think have been fascinating. And I sort of like the 1-2 punch of the fact that and certainly this is all supported by the National Self-Storage Association, that they recognize these sort of pain points for self-storage operators and are now addressing them legislatively. So let's talk about the enforceability of the rental agreement being sent to the tenant electronically. What do you like about it?
Well, I think what we have now, and it's actually a little bit broader than that, because in a real sense, if the tenant has, sometimes tenants won't sign rental agreements. Let's just face it. They're for whatever reason, they got past the moment, either online or at the facility, and then they decide, well, they kind of dig their heels in from time to time. And one of the nice things about these laws is they do cure that problem, where if they continue, the real nexus of this is the fact that they're using the storage unit, and that they're staying in the storage unit, and at some point that rental agreement that they had an opportunity to sign when they rented the space, but for something went wrong, which does happen, but is sent to them via email or other means, they can't just ignore the fact that they have a copy of the rental agreement that was presented to them at the moment of rental, and for some reason didn't get signed, and say, doesn't apply to me. Under these laws, it does apply to you if the tenant continues to occupy the storage unit. And that's the real the real nexus of this. It's that occupancy that essentially creates assent.
Yeah, and I think that, logically, it makes sense. You're sending out an agreement to the email address or last known address provided by the customer with the rental agreement, the terms and conditions that apply to their occupancy. They have the opportunity, of course, if they don't like those terms and conditions, to terminate the lease and vacate. But the way the statute reads, the continued use and occupancy of the space after the receipt of the notification just makes so much logical sense to me, that the tenant now is deemed to have accepted those terms and conditions by the decision to continue to occupy. Seems fair. It seems to clean up a lot of the loose ends on this sort of question. And it should make operators feel better about the fact that they can update their rental agreements by sending notice to their customer. If the customer continues to occupy, it means that they've deemed to have accepted it, especially in these month-to-month lease agreements that are part of our culture and tradition of the industry.
No, it does make a big difference with respect to, and I think you pointed that out with change of terms, which are always kind of a funny thing, where you're trying to change terms and you're sending out first class notice or something like this. It really does recognize that the way that we're starting to communicate with our customers is via email, that these are getting delivered to the tenant's email address, and if I don't like a rent increase, I can vacate. If I don't like a change of terms, I can vacate. But I can't stay there being told that this change is going to take place, and just assume, well, it doesn't apply to me. That's not going to work anymore.
Yeah, I also wanted to point out that on this unsigned agreement provision, also Utah and Virginia can be added to the list of states that have included that unsigned agreement language. And I may have overlooked Utah also has the non-monetary default statutory change. So we're talking again, Georgia, Idaho, Kansas, Utah, and now Virginia on the unsigned agreement. And I know you mentioned California. Are there others that are I know that there's a broad-based effort to make these changes in multiple states. Any others that are outstanding?
Yeah, I think there's still some states that I think I could be wrong on this, but I believe there's a bill in Illinois and some other states whose legislatures, a lot of the legislatures have already closed, and so we're the clock is running down on the ability to actually enact things. But some of the legislatures, basically they're active to the end of the year. And so there's a possibility that before this year closes, that there might be a couple more.
Okay. So one other legislative news for me hits home for self-storage operators. I don't know if you're ready to jump to it, but this junk fee drip pricing law out of California. What's your thought about that law and the impact on self-storage operators throughout the country?
I think these laws, and again, right at the moment, we're primarily talking about California. These are not ubiquitous around the country. Most states don't have laws governing this, but there's a lot of interest in it. And also the FTC is looking at this same issue on what we call junk fees, and sort of if you want to know what this is about, it really was the hotel resort fee. They'd advertise the room at $200, yet there was a daily resort charge of $39. So the question was, well, my actual room rate is $239. And I always figure, congressmen do a lot of traveling, and I think it might have irritated them. So that's why there's interest in this area, both at the federal and state level. But the one thing that I think to keep in mind is this doesn't really affect what you're required to disclose. You've always been required to disclose every single thing that a tenant must pay before they swipe their card if they're doing an online transaction. What this does is it changes the timing of when certain of these fees are disclosed during the process, because the resort fee was always disclosed at the swipe point. Well, they decided that's not soon enough. If you're going to have these kind of fees, these drip fees or whatever you want to call them, you got to tell us about them sooner. So the real question is, how does this affect self-storage? Well, there is one charge that everybody pays. I shouldn't say everybody, but 99% of the facilities charge an admin fee. And it can be anywhere from, $10 to $30 is probably sort of the range of it typically. And the question is, it's a one-time charge, so obviously you wouldn't include it in the rent, but is it a fee that under this kind of, under this type of law, do you need to disclose before the person gets to check out? And
my answer is yes, and I think we all see that it should be, and that the websites of our operators are being updated to address the notification of that one-time fee to clear up any confusion that the customer may have with regard to what their rental charges are, at least on that first transaction. As you're talking, I know that the statute in California references the terminology of disclosing mandatory fees. And then it strikes me that we've sort of had this sort of thought process out there in the industry for a long time. I mean, New York has specific reference to making sure that the rental agreement includes every mandatory fee, and it's stated in the statute with reference to mandatory fees and the importance of disclosing mandatory fees. I think now we're just seeing how important it is in the world of website advertising and marketing and online contracting that the tenants have the opportunity to know what they're paying for before they pay it.
Yeah, no, I agree that the fee can be disclosed, and there's, You sort of look at the technology. It can be a banner over when you list all of your size rentals, your 5x5s, or $100, your 10x10s, or 150. There's a little thing over the top of that says there's a one-time administration fee. It can hover. There's a lot of ways that this can be done. So the technology is out there. That's not a problem with this sort of what I'll call pre-checkout disclosure of these kind of charges. Let me ask you about one other kind of charge that self-storage operators have, and that's insurance. Probably the typical self-storage rental agreement requires the tenant to insure their property. Now, they don't require that they necessarily buy that insurance or protection plan from the facility. But when you have a facility that has 89% of their customers participating, what does that look like to you, Scott? How do you look at that?
Yeah, no. I think the phraseology we see in the industry is considered to be automatic enrollment with the opt-out by the tenant with a show of proof of insurance or protection plan outside of the facility. And I think that it's really important. Look, if we back up and look at the concept of tenant insurance or protection plans over tenant stored goods, it's such a vital piece of the self-storage experience that tenants have insurance or protection over their stored goods, because the operator, by law and by contract, don't take care, custody, and control of the property in the facility. And the tenant assumes the risk of loss when they store at a facility. So how do they protect themselves on that risk of loss? Is through insurance or protection programs or third-party coverages, something that would ensure the risk of loss of that property. It's such a vital piece of the sort of the experience of self-storage that the property that they're storing is insured from the risks that are inherent in any facility. I don't care if they're fourth, fifth, sixth generation facilities that are perfectly newly built. There's always a chance of break-ins or tornadoes or storms or fires. I mean, it's just the risk of storage. So I've always been an advocate of the obligation for the tenant to assume that risk by providing proof of insurance or assuming that they are otherwise enrolled in the program that's being offered. But you're right that this ties into this drip pricing question. So if there's an automatic enrollment with an opt-out and therefore an automatic charge upon rental for the insurance or protection plan, it has to be disclosed. It has to be disclosed just the same way that a one-time admin fee is disclosed, so the tenant knows what they're being charged to rent at that facility. Would you agree?
Yeah, I think so, because I think what makes this, it's where you have that automatic. I think if it's purely optional, the operator does nothing, with respect to the customer, but doesn't enroll them in the program, but says you got to have insurance. We have it here, but doesn't force the issue. I don't think it needs to be disclosed. But if you have automatic enrollment, I agree with you. I think that's really the nexus where the kind of the rubber meets the road on that insurance. It's where you have automatic enrollment.
And then the last piece of this whole pricing thing that I think we should even just talk about just for a few moments is what we're seeing in terms of the flow of occupancy in the industry and the pressure on rent discounts, rent concession, rent promotions, and the clarity that if there is a promotional period of a lower rent at the facility, essentially the $1 move-in, that the tenant also has clear understanding and expectation as to when that discount burns off and when they are going to be sent a bill for the standard rate of renting at the facility. I think I've seen too many tenants have bad reactions when they're paying some discounted amount for the first few months and then get hit with a full rental charge and then challenge it, basically saying, well, I didn't know. I mean, I didn't know it was going to be that expensive, or I didn't know that's what you were charging, or whatever. So, I mean, the disclosure piece, especially on the website with regard to rent discounts and promotions and concessions, I think is a point to avoid not just the California law on junk fees and pricing. I think this is an across-the-board issue that could be subject to state deceptive trade practice lawsuits or claims if the facility is not clear about when its rent discounts burn off. Any thoughts on that?
I agree with you, and I think that there's another problem here that isn't just a discount. It's where you can move in, and the move-in rate is $60 for a 10 by 10, and the operator raises the rent at the 60-day point. Let's look for an example. That rent increase was built in the day that space was rented, and the owner knew about it. And I think that if you don't, make it very clear to the tenant that this rate can be, raised on 30 days notice at any time, I think you're being deceptive if you've already planned a substantial rent increase at when they're 2 months into the tenancy. I think it's a problem, and it's one that really needs to be thought about in how it's presented to customers and what customers know when they rent that space, because, going from $60 to $150 after 60 days is going to, is going to make people unhappy. Let's put it that way.
Yeah, but I want to sort of put an asterisk with that, is that I think you'd agree that that contractually, a facility can charge whatever it wants to charge, what the market will bear for its unit. It's the issue of not creating surprise for the customer as to what that rent would be. I mean, they could double the rent if they could get away with the market supporting it. It's just the fact that they need to create disclosures about the ability to increase the rent, or if they know when that rent's going to go up, giving the tenant notice of that far enough in advance.
Yeah, no, absolutely. I think that they have to know that, basically make sure the tenant understands that, we're not promising you this rate for a year. This rate, can be very clear that this can be raised at any time on 30 days advance written notice.
All right, so you brought up a topic that you wanted to talk about that I think is a really interesting one, about taking over a troubled facility. Is that an issue that you've seen come over your desk recently in terms of operator frustration?
Not necessarily frustration. I think a lot of operators look at badly run facilities as an opportunity when they're buying them. The one thing that I want to make sure I've talked to, I've had this come up a couple of times actually already this year. And, the one thing I impress upon them, understand that this is not a problem that gets solved in a month. It's a problem that can take several months to resolve, because you're buying something where you may have, unbelievably bad tenant records. You have spaces that you have no idea who's rented them. But on the other hand, you were able to buy a 400 space facility at a very good price. And as long as you sort of understand the balance, I've known operators that have bought badly run facilities, and a year later, they're really pleased with what they purchased. I think some operators do this, maybe less experienced. They buy a facility, and once they take over, the situation is a bit of a surprise, because they weren't expecting to find that the internal records and rental agreements were, let's just say, messy. And so, and resolving this is something that takes some time. But I think if you're diligent and you go about it methodically over a period of 3, 6, even up to a year, most of the problems will get resolved. But you just have to be patient, and you sort of go in with the idea that there are going to be a few that never get resolved, but hopefully those spaces, what's inside reflects the fact that the person who rented it may have long ago lost interest in that storage space. Because we do find that what I'll call the effective move out in this industry is not unusual. The tenant just kind of disappears, and there's some stuff in the space, but it's probably just stuff that they didn't want to take with them.
I think the terminology that's being used is similar to employment. They call it quiet quitting, or
Yes.
quiet vacating, or quiet termination, as tenants that simply at some point stop paying the rent, stop caring about their property, probably never wanted to store it to begin with. And in these transition facilities where the new operators don't have the ledger or the lease and really don't know, a lot of these units, I agree with you exactly, over time will dissipate. And if the tenant's not showing any interest in the property, the eventual disposal of the property is pretty low risk choice for the operator. If they don't otherwise know who the tenant is, they can't do a lien sale. They don't know who the tenant is. And over time, it's sort of the risk factor goes away. I think you've heard me say this before. I call those investigations into those quote unknown units my Columbo units, where I want an operator to put on their Columbo, raincoat and hat and go into those units and open boxes and look what's in there and see if they can discover who the tenant is.
Yeah, no, I think that's good practice. And also, when you're doing this process, I mean, to some extent, you can, triage the spaces. You're going to open up some, and you're not going to be too worried about ultimately having to dispose of the contents, because the contents are essentially have little to no value. The ones that are going to be a little more troubling, where it really looks like somebody is storing property in this space, and you don't have you don't have good contact. But again, if there's real stuff, then they may come to the facility one day, and you may be able to resolve it. That's why it takes time. And again, if there's significant problem in a storage space, you're not going to act too swiftly. You're going to give this one some time and realize that's part of what you bought when you bought this facility with its problems. And it's going to take you some time. Eventually, you may ultimately have to dispose of a space like that, but that's not one you're going to be doing within the first 90 days. That's one that's going to be a little farther out there before you actually take steps, because you're going to do what Scott suggests: do a little due diligence, do a little investigation, and try to figure out what's going on. Why is there this, kind of normal contents for a self-storage space, and yet I can't figure out who rented it?
I think the goal of a lot of these acquiring property owners of these facilities is what I guess we all call the value add. They get a facility that is not properly managed, haven't adjusted their rates, haven't provided some of these enhancements that would allow them to charge more for the facility, do some additional maintenance, do the work that is needed to create value to the property. But often that comes with these value add properties is exactly what you're talking about, Carlos: lack of ledgers, lack of leases, and a lot of unknowns. And that's the value of the discount that they're going to get when they acquire the property. But I think your message is a great one. If you're going to take that opportunity of the value add, it comes with risk, and you have to balance the energy of trying to do a quick fix by recognizing that some of these units are going to take time to work themselves out. And that's just a reality of the business. When you buy a facility that has hundreds of units, there's going to be some units that you're going to have to live with if you haven't properly done the due diligence on the acquisition, that you're going to have to live with for a while to assume a reduction of your risk of liability. Let me ask a question with regard to this acquisition and the due diligence of lesser operated facilities. What's your philosophy on good sale and disposal insurance?
Good sale and disposal
insurance.
Oh, I think it's I think it's a must-have in the industry. And I think that, it's been around for a long time. I mean, both Deans and Homer and Minico, I think, started marketing it back in the early 80s. So it's nothing. And, it's just one of those coverages that is, it's unique to self-storage. You want to have that kind of coverage, and you want to have it in, realize it's a little different than, other kinds of coverage, because it deals, you're not going to have, probably, unless you're really running your facility badly, these type of claims come one at a time. You don't have a situation like Customers Goods Legal, where you could have a fire and a 40-unit building is burned to the ground, and you've got all of these claims to deal with. These are going to be, one claim because of something happened at a particular sale. But you want to have, decent units, $250,000, maybe more, depending on what you're doing. And again, it's in my mind, it's one of those things you do because it allows you to sleep better at night. Because you will, if you have a good size facility and you're doing sales, every couple of months, over the course of 5 years, you're going to have accumulated a certain amount of contingent liability. Because all of those past sales, there's a possibility of a lawsuit. Now, the likelihood is low, but they do happen. And having that insurance coverage in place is really important.
So since you're staying up at night worrying about fires, let me ask you a question that's been out in the industry recently, is about storage of lithium-ion batteries and what operators can and can't do with respect to that presumed hazard item for storage. I would equate it to, propane tanks or other flammable materials that people store in their units. What, if anything, can an operator do to address the anxiety about the storage of lithium-ion batteries?
Well, you can have insurance on your building, and Customers Goods Legal insurance, and general liability insurance. But I mean, let's take a look at that as a practical matter of how we run our businesses in self-storage. Unless you're going to start looking through what tenants bring onto the premises, there's not a lot you can do if a tenant chooses to store lithium batteries, a large quantity of something like that. You can certainly put something in the rental agreement. It might actually be more helpful if you put it on a sheet of paper, do's and don'ts of self-storage, and say, these are things you really don't want to put in your storage space, because this is not just a threat to the storage facility. This is a direct threat to the tenant's contents, and it might be helpful if they're given something, these are things you want to avoid, rather than think there's some formal way of doing it. Unless you're going to really think about changing how we operate self-storage, which is to emphasize the self. We rent a space, the tenant puts stuff in the space. But again, I think you might want to, self-storage do's and don'ts or something like that. So self-storage, so the tenant, who may not, be really give it a lot of thought, might at least be alerted to the fact that this could be a problem.
All right, I think we've covered our topics, as I like to do at the close of every legal chat, just to make sure our listeners keep entertained with our lives. Carlos, since the last time we've done this, you've spent a month in London. Do you want to tell us all about your British perspective now of self-storage?
If only it were so. I spent 2 weeks in London, which is good. But Janice and I, with my wife, we go to London quite frequently. And it's one of those places when we go, we tend to stay 10 days, 2 weeks. And the reason is that back in 1985, Janice was the law librarian at Hastings Law School. She was the circulation librarian, and she did a job exchange, a 3-month job exchange with a London librarian who worked at what was called the Inns of Court, which is the solicitor's library in London. And so for 3 months, she worked in this library. and made quite a, I think she made 4 friends there, and then the person that she did the job exchange. And she has stayed in contact with all of these. So on our last trip, we visited every single one of these people. So it's not just we're in London. We actually have some social contact when we're there, which makes it a lot of fun. And then there was a second reason why we went at this particular time. And if there are any gardeners out there in London, usually sometime in June, they have what is called Open Gardens Weekend. It goes on Saturday and Sunday. And if you've been to London at all, you'll notice that there are squares and things where these lovely little gardens, but they're locked. If you don't have a key, you can't go in. And a lot of these open up, and a lot of gardens that are just not generally open to the public open, and then a lot of things, but it's a really fun kind of thing to do. And you sort of plan your walking tour so you can maximize your gardens. But Janice is gardening is her hobby. And I love going to gardens. So it was, we had a really good time in London, and it's a place that we're just really familiar with.
I'm trying to picture you right now with a white wig as a barrister. It's already pretty white, but I mean, I'd love to. Next time you should probably don the barrister wig so we can all get a feel of British law from you.
I don't need a wig. I just have to have my hair rolled in the right fashion. But no, it's I enjoy London. We also went to Stockholm on that trip, and it was really nice. Just a beautiful city because I like watery places, and it's one reason why I live in the Bay Area. I love Seattle, and Stockholm is a very watery city.
Sounds lovely. I hope between now and the next time we do another legal chat, you'll be able to regale us with another travel experience or some other updates. All right. Well, this
I may be asking you about Atlanta and what's going on. Is this going to be the first time they don't win the division?
Well, that we'll know a little better the next time we get together. We'll have a little update since we're right before the All-Star break. Yeah, we'll bring up the Braves Giants the next time.
That we don't have to. I mean, it looks like Atlanta will be in the playoffs. It's just sort of their dominance. I see cracks, Scott.
I know. We're coming back. We'll have some picks, I'm sure, of some players off the waiver wire somewhere along the way that will surprise everybody and change the whole season. But all right. Well, it has been a pleasure, Mr. Kaslow, to once again do a legal chat with you. And we want to thank Lighthouse Storage Solutions for all of their promotional and preparation work for these legal chats. We really appreciate Josh and the group with the wonderful video format and production of these programs. Thank all of you for listening and tuning in. And our plan again is to do these quarterly, so we will do one again in the fall. Hope to see many of you at the National Self-Storage Association Conference in Las Vegas, where Carlos will be presenting. And we will always be available for you if you have questions to reach out to the Self-Storage Legal Network. You'll have our emails and information as part of the materials that are broadcast. So thank you again. Thank you all for joining us on the Legal Chat for the Self-Storage Legal Network. We want to thank Lighthouse Storage Solutions for producing this with us with the Self-Storage Legal Network. Again, you can ask questions for us for our future sessions that are going to be on YouTube. We're going to do these 4 times a year at the email below. And certainly you can reach out to Carlos and I via our emails if you have other questions about what we're doing. And certainly you can reach the Self-Storage Legal Network at www.selfstoragelaw.com. Again, thank you.
Thank you.
We'll see you soon.